Good afternoon. Keep eating. We try to start these programs in a timely fashion because we want the judges who are here to get back by 1:30 or leave here at 1:30 promptly so they can continue their jury trials. This is Chicago's first jury improvement lunch, the 30th in the nation. I'm Steve Sussman, the executive director of the Civil Jury Project. Hopefully we'll get this feedback solved. And this is by far the best lunch thus far that we have had in the country. 19 judges said they were coming. Most of them are here, but the weather's been kind of a problem. We have 8 jurors. Hopefully they are here. And in all, there are more than 100 of us. So it is a testament to the well-being of jury trials and trials in the city of Chicago. There are some cities where there are so few trials that it is very difficult to get discharged jurors to come. You can tell whether the judges are interested or not by whether they show up. And so I'd say the health of the jury trials in Chicago is probably better than elsewhere in the country. I'd like to, instrumental in making this happen today, were 2 judges, Chief Judge Castillo of the Northern District of Illinois, the federal courts, and Judge Claire McWilliams of the state court system. Both have been judicial advisors to the Civil Jury Project from the very beginning. Judge Castillo was so nice as to say we could have this lunch at the courthouse until we found out how many people were planning on attending this lunch, and we had to come get a ballroom. And our jurors here today, as you will find out, most of them are here because Judge McWilliams beat the bushes and got them to come. So I would like to welcome Judge Castillo to come up and say a few remarks about jury trials and to introduce his colleagues who are here from the federal bench. Judge, here's a mic.
Thank you. Thank you. Thank you, Steve. Whatever Steve asked me to do, I'm going to do. So I can tell you, even right now, I just instructed a jury. Jury's deliberating, did back-to-back jury trials, did a patent jury trial last week. You would especially love Monday, where I had a jury deliberating while I was picking the jury right now that is trying to reach a verdict. But the problem is that doesn't happen too often. In fact, hasn't happened to me in quite a while of doing back-to-back jury trials. So there's a lot of work to be done. Why should we have more trials? I think it is a rare opportunity for judges and lawyers to interact with the citizens of this great city and this great district. So I'm a big believer that the jurors that are going to leave my courtroom today or tomorrow, they're going to have a better feeling about the law. Aside from the fact that last night I was at Northwestern Law School teaching trial advocacy, and I don't teach mediation, I don't teach settlement. I teach trial advocacy because my love was trying cases. And from there, it's easy to become a trial judge. And I would hate for us to just be judges without trials. I think that is something to be avoided. That's something that in the end is going to hurt our democracy. So I welcome my state court colleagues for being here. And let me get to the task at hand. I think we have Judge Durkin, Judge Feinerman, Judge Guzman, Magistrate Judge Finnegan, Judge Kendall, Judge Lefkoe, and the next Chief Judge, Judge Pallmeyer. If you would all stand and be recognized. And so I'll pass the microphone back to you, Steve. Look Looking forward
Thanks.
to the program.
Judge McQuaid.
Thanks very much. Good afternoon, everyone. It's so nice to see all of you here, especially all you trial lawyers that are here. Hopefully, you'll gain a lot of great information today, and I think that you find after your jury trials that when you discuss your cases with the jurors, you walk away with the most information that you can have going forward in the future with learning how to be a better lawyer and how to facilitate better trials for yourself. As most of you know, in the Circuit Court of Cook County, we are what's known as a master calendar as defined by the National Center for the Courts, which is the administrative arm of the United States Supreme Court, which means in Cook County we have judges that handle different facets of the case. So we have about 20 to 25 trial judges, and all we do are jury trials. We hear another case. We've got motion call judges that hear the cases. I like to characterize it as from the first to the 8th inning of the ball game, and the 9th inning goes to the trial court, and they meet the lawyers for the first time. They try the cases. It goes to a jury verdict, and then off to another trial they go. So in Cook County, we have approximately 400 to 500 verdicts each year based on the huge volume of cases that we have coming in. And I'd like to introduce the state court judges which are here. Most of the judges here today are in the Law Division of the Circuit Court of Cook County and do hear trials each and every day. Judge Ahern is from the Domestic Relations Division. Morris Slattery Boyle is here. She's one of our newest members of the Law Division and came from our state criminal court. Judge James McGing is here, who is also the Celt of the Year. Congratulations, Jim. Judge Joan Powell of the Law Division, Judge Lorna Probst, Judge Marguerite Quinn, Judge Patricia Sheehan, who is a motion court judge, Judge Rena Van Tyne, Judge Varga, and I believe I have Judge Harmoning here, who I've seen, Judge Lynch, and Judge Lipscomb. And sorry if I missed anyone, but if all of the judges from the state court could stand and be recognized. Thanks.
So, the Civil Jury Project, which was established 3 years ago at NYU Law School, is the only academic center in the country that is devoted to asking the question, why are trials decreasing so quickly, almost disappearing? And is it something we should care about? And if it is something we should care about, is there anything the bench and the bar can do to solve? I no longer believe we can reverse the trend, but we may be effective in stopping the decline. And so I don't think anyone in this audience questions the importance of jury trials. It is, after all, the only right mentioned in five times in our founding documents. The Declaration of Independence, Article 3 of the Constitution, 3 of the Bill of Rights talk about jury trials. That was, if you read the Federalist Papers, that's what a lot of the arguments were about. How do we preserve jury trials and guarantee them? And in fact, our founding fathers knew that jury trials would be more expensive, would likely take more time, had the possibility of appealing to the emotions of ordinary citizens, and skewing the result in that way, and they didn't care. They still wanted their jury trials. And as a result, there's not a courtroom in the country, not many, at least. I actually saw one in Chicago in your Chancery Court, but there aren't many courtrooms in the country that don't have a jury box. But the unfortunate thing today is that those jury boxes are empty most of the time. This graph that I'm going to show you now, the red line represents jury trials, the number of jury trials per average federal judge. So you take the number of jury trials in the country, you divide by the authorized federal judgeships, and you come up with a number, and you can see that number's gone from 10 in 1962 to about 2 per judge today. The blue line, which is I never knew this was happening, the blue line represents bench trials. They've gone down faster and quicker than jury trials. And so that the average federal judge in this country last year tried one civil bench trial, for a total of 3 trials, 2 jury, one bench on the civil side a year in the federal court system. And there's nothing that's indicating yet that that trend is going to reverse itself. You can say that, and if you look at, I've looked at the statistics here in the Northern District of Illinois. In 2018, the average was above average, 3.2 per judge, and bench trials were 1.9, which the Northern District of Illinois comes in 9th for the district court with the most jury trials per judge, 10th for the most bench trials per judge. If one would make the claim, well, the absolute number of trials is declining because there are fewer cases being filed. If you look at the percentage of cases being terminated by bench and jury trials, you see the same declining trend. So that the number of, it's under 1% today, almost 0.5% of all cases in the federal system get terminated each year by a jury trial. The situation in state court in Chicago, I have not been able to get those statistics. But I'm pleased to learn, and I think in Chicago, the state courts are doing probably the same trend over time, long period of time, but certainly a lot better than the federal courts around the country. I've gone around and I've concluded that that is a consequence everywhere else of going to, instead of a central docket, going to individual dockets. So sometimes in the 1980s, the idea became very vogue in this country, we should have managerial judges. We should have judges that know how to dispose of cases, meaning get rid of them without trying them. To where some judges would actually say, if I have to try a case, I'm a failure. And that's been kind of the metric, certainly in the federal system. The trend line in the federal system is exactly what the business community set out in 1980 to accomplish. Reduce the amount of litigation going on in the courts of this country. Either stop litigation altogether by eliminating causes of action, or move a lot of it into federal court where you could make it very difficult, and they did, to go to trial. And they've been very successful. And that 40-year trend is something that it's going to be hard to reverse. Because if you ask the average citizen, what word they associate with frivolous, the answer is lawsuit. Frivolous lawsuits. And so it's just proof that the policymakers in this country at the federal level have pretty much accomplished what they wanted to accomplish. And of course, why this project is so pertinent today is now at the state level in your state courts, this central docket does cause a lot more trials because you don't have judges are not rewarded for clearing their docket because they don't have an individual docket. And it's a different metric. And the only other place in the country where I know that is true is in Baltimore, city of Baltimore. I've been there. They made the claim to me that they have plenty of trials, and in fact, when I looked at the statistics, I wouldn't say there are a whole lot of trials, but there are a lot more that are taking place in other state courts and federal courts around the country. So what have we done at the, besides put on programs? This is our 30th lunch like this we have held in the country, and there are a lot more scheduled. And the notion is, one of the first projects we looked at when we were started was, is the average citizen aware that trials are disappearing? Because if they aren't, they will disappear. And what we found is that we did a survey, and 80% of the people who are not lawyers thought that in the last decade, the number of trials in this country has increased. Totally inconsistent with the facts. No one argues the contrary. What causes that? The popular media, the idea that someone has put in their mind that there's a litigation explosion, that there's a judicial emergency, that we need more judges or more courthouses or whatever it is. You can go into most courthouses in the country today or any day during the week and shoot a cannon through the hall and you wouldn't hit anyone. It's totally changed since the day I became a trial lawyer about 50 years ago. And, you know, if we need to make the public aware that this is happening. And so that's one of the things. So one of the things we've done is have programs like this where we bring jurors and judges and lawyers together, because my notion is that if we keep talking about things, we may change them. We have done other kinds of empirical research. For example, by examining the dispute resolution clauses of over 6,000 public contracts entered into by publicly held companies and filed with 8Ks at the SEC, we have discovered that 57% of the contracts, which you could say maybe it's 50% of the companies, they do not have a jury waiver or arbitration clause in them. So there's a large part of corporate America, and we have confirmed this by interviewing the general counsel of some of those companies. There's a large part of corporate America that still says when we have a dispute with an equally large and sophisticated entity, a business-to-business material contract, we want it decided by a jury of 12. We want it subject to being set aside if it's crazy by a judge, and we want that judge reviewed by want that judge's homework reviewed on appeal, none of which we can get in arbitration. And they have come to recognize slowly, but this needs to be publicized too, that discovery, arbitration is just as expensive as litigation. The discovery's about the same. You cannot get dispositive motions granted. It takes a lot longer. I mean, it's hard to get the statistics on arbitration because it's not public. We can get it on litigation. But to the extent that we can get a peek into what's happening in conference rooms, it's not, trials are not disappearing because it's cheaper or quicker to get them arbitrated. So we began the program by asking a number of federal judges and state judges to be judicial advisors. We now have 300 judicial advisors. We maintain a website. This is the civil jury. This is for lawyers and judges. Every one of these lunches, 30 lunches, is videotaped. The video's on the website. There's a lot of articles on the website, studies on the website, testimonials about jury trials, and a list of our 300 judicial advisors. We have 60 academic advisors. These are academics, law professors largely around the country that are doing research on jury trials. And we have 40 now jury consultant advisors who are helping us test a number of innovations that we are trying to propose. One of the things we have learned, and one of the things we think we can do, is that the key here to jury trials will disappear if lawyers who know how to try jury cases disappear. And everyone who's my age and who's been doing it a long time knows that's happening. I mean, the American Board of Trial Advocates can't get members because no one has tried 10 cases first chaired a verdict, no matter who you are. I mean, there are few, but very few. And they're going to have to do something about that. I heard on television this morning on CNN, it shocked me. There was a review of the presidential appointments on our courts of appeal and our trial courts. Not only has the president been successful in putting people on the bench, he has put on the trial bench people who have never tried a case before. This is pretty scary. One was just added to the Northern District of Texas, who, when he was interviewed, told us he had actually never attended a trial. He had seen them on TV or movies. So we're getting people put on the bench, and you got to ask the question, the first time those people get a summary judgment motion, what do you think, who's going to get the benefit? Why would they risk embarrassing themselves in public by going to try a case where they have not had any education? If you look at the curricula, the new federal judges go to school for 2 weeks. There is nothing in that curricula about how to try a jury case. So it's a matter of judicial education too. We have to get the judges comfortable and liking, being excited about it. Like Judge Castillo was excited to tell you about his trials. He's going through an exciting professional experience now. We need to get other judges to have that experience, because if they do have them, they are not going to hesitate to try cases that need to be tried. We have put at your table a list of the reasons that trials have declined. We divide them on the left side to reasons that we can't do anything about. So why worry about them? I mean, you can worry about them, but there's not much we can do about it. And on the right side, we list the reasons. There are 8 reasons that are within the control of the bench and the bar. And they range from reducing the expense of public dispute resolution, which is a project of every bar association and bench in the country, to training young advocates, and that's what this lunch is about, listening to jurors, getting feedback from jurors on what we can do to preserve the remaining trials. We had a lunch like this on Tuesday in Des Moines. The Judge Jarvie, the chief federal judge of the Southern District of Iowa, talked about the 7th Amendment guaranteeing that jury trials will be preserved. He said the issue is not whether they're going to be preserved, it's going to be whether they're preserved like the Egyptian mummies are preserved. And that's right. And so the reason we are doing these programs and suggesting these innovations is to make sure that jury trials are improved, are better, there are good experiences for the jurors and good experiences for the litigators. One of the ways we get feedback from jurors is we have a second website called WeThePeopleWeTheJury.com. We advertise that to discharge jurors by a card that we ask the judge to deliver to the jurors when they are discharged. And judges, you have those cards at your table. If you have not received them before, please take them. And this is at the end of the case, you hand this card to the jurors and explain to them, if you want to talk about your experience and blog about it and say things about it, you go to this site. Now, whenever we get jurors together, as we are getting together today, and we're going to have them come up here to this panel, or when they click over here on serve jury duty before, we tell them, do not talk about the facts of specific cases. We are not interested in what happened in the jury room. We, in fact, are not interested in making this, the judge was great, the judge was terrible. Don't talk about the specific judge, and don't talk about the names of any of the lawyers. I mean, you can talk about general what lawyers did or what would have improved, or even judges, but we don't like to name names. But we have had thousands of jurors come to this website and fill in questionnaires. So we kind of are getting a feel now of, and we give judges, and we've given each of the judges who are judicial advisors, and we'll give the others here today, a questionnaire. You will see, now these 8 that are coming up here, one of the things about them, and thank you very much for coming, is that none of them were on a jury this year. We have had to go back to 2018 to get people who were on juries. Memories fade. We get people that remember their jury duty and they remember parking was terrible, the cookies could have been improved, but they don't remember a lot of other things. Hopefully our jurors here today will have better memories. So the key is, we have found, is get to the jurors right after they serve. We urge the judges to give them a questionnaire at the beginning of the trial and tell them, this is a questionnaire you can fill out whenever you want to. I don't want you to be distracted by it, but you're going to have an opportunity to tell us everything you saw or heard that you didn't like or can be improved. So think about it, and please turn it in at the end of the trial. And if you don't want to turn it in to me, give it to the bailiff or send it to NYU, and the address of our project is there, and we get some directly. The other thing up here, and this is kind of an accident we have found by working with this website. One of the biggest problems around the country today is yield of jury summons in response to summons. People ignore them. Many places get like less than 20% response to a jury summons. So people, and most of the people who come to this website, unfortunately, even today, come because they are looking for a way to avoid jury duty. And they come upon this site. And we try to get them to go to receive a jury summons on the left. And when they go there, and I urge you to go home tonight or to your office and look at it yourself, we have terrific jurors give testimonials. We identify them through these lunches, and when the lunch is over, we ask them, would you stick around for a few minutes, and we'll interview on video, and we'll cut it down to a couple of minutes and then post it here, so that when those people get a summons and they go here to figure out how to get out of it, actual jurors say, don't throw away your summons. You're about to have the best experience of your life. And hopefully, over time, we will improve the yield, because my experience by talking to thousands of jurors now across the country is that if they will talk to you, now there's a self-selection here, if they will talk to you, they love the experience. They had a terrific time, and they would want to do it again. And so, yes, we are getting, when we talk to jurors, most of them are very, very favorable. But that doesn't mean we don't want feedback from them. And these people we reach by social media. We have a Twitter and Facebook presence called Juries Matter, and or Jury Matters, and they find our site by going here. Now, what we're going to do now is we have 8 jurors here. I would ask you all to come up and take your place at the head table. And just come up. I'm not going to introduce you individually. Come up here. Hopefully you're all here. And thank you very much for coming today. It means a lot to us. And Judge McWilliams, where are you? Would you come up and help me here? Would you rather hold a mic, or you want? Okay, and this table's too big, so let me tell you, and tell the audience a little something about these people. And thank you for. We got a little questionnaire from them all, so we know something about them. Of the 8 who are here, 7 served on state juries, 1 served on a federal jury. They were all civil juries. They all were on juries that returned a verdict, I think. You can correct me if I'm not summarizing it. Rather, it will take the whole afternoon to get your individual experience. There was one juror that his questionnaire says he was on a 7-month trial. Are you the 6 to 7 month trial? We got to really talk to you, because
Glad you made it out of there.
one of the things this is a rarity. This is a juror who's been in the longest serving juror that's come to one of these events. Normally, the jurors who show have been in 2 or 3 day trials, but the trials, some of you were in week-long trials, or there was someone in a 2-week trial. The deliberations lasted from a few hours to a few days, usually. So, I mean, I think the best thing to begin with and ask you, and I'll step down and go to make sure I take my notes with me. Go and have something to say, pick up the mic, speak into it, and don't let Judge McWilliams or I ignore you. I mean, it's a long table, and it's hard to see everyone. So, and was I correct that your service was last year? Has anyone served this? You're all last year jurors. What? You were 2 years ago. Even more difficult to remember, but we want you to search your memory today. And I'm not going to ask you to begin with about what you loved. I want to ask each of you to give us a little about what you think could be improved. Cunha? If I got it right? Cunha. Miss Cunha, what can we now you're talking to, I will never have the opportunity again to speak to 19 judges. So we have 19 judges here representing a lot of the trial activity in this city, and they're here to listen to you, not me. So what can we do, what could be done to make the experience better for you?
For me, the location was great, Daly Center. The treatment was fine. Maybe the sandwiches could have been a little bit
I said cookies, didn't I?
fresher.
Where's our chief? Oh, darn.
That's all I can think of.
All right. Mr. Oftenkamp?
Yes, sir.
Mr. Oftenkamp, tell us what we could do to improve it?
I think the compensation's pretty low. I think everybody at the table will agree with that. I thought there was a fair amount of redundant testimony where it's like, yeah, we've been over this. And then it just seemed like, I don't know, I'm sure this is hard to not have happen, but there seemed a lot of like, oh wait, we have to go back outside. We talked about this, you can't do this, you guys hang out.
Wasted time?
Yeah.
Okay.
Sidebars, is that what they were referred to, the sidebars that were taking place?
Yep.
Now, were you sometimes sent back into the jury room?
Correct.
And some jurors complain that they got there on time in the morning, but they had to wait for someone who didn't get there on time, or they knew one of the lawyers. They were told the lawyers and the judge were doing something important in the courtroom, but they didn't believe it. They thought someone was late coming to court, and they were being forced to sit back there. Now, by the way, which is something all the judges can do something about by simply telling the lawyers, we are going to begin at 9 o'clock or whenever you start, and if you're late, it's going to start without you, and you're going to be forced to walk in during the trial and take your place at counsel table, because jurors are not going to sit there. Lawyers will be there on time. Lawyers have gotten, unfortunately, and the bar needs to listen to this, horrible habits. Nothing that is ever said, we don't expect it to go in a timely fashion. We don't expect we have to be there on time all the time. We sometimes don't even expect we have to be ready, prepared, and that's another big complaint. Lawyers are not prepared. Mr. Kelly,
Go ahead.
No, you, go ahead, tell
I
us.
mean,
What do you think?
Yeah, I mean, I think my father was an attorney, so I have like a basic understanding of how this works. But the compensation, that wasn't really an issue to me, and I have a pretty good job. But I think a lot of people are going to look like, is it worth my time? And then they don't see that they'll ever be on the other side of the table. And I never looked at it that way, but I can see where people would. And then the other thing is if it dragged out a long time, like you mentioned, for several months, I mean, if you're like the vice president of a company, there's very little chance that you're going to be able to sit on something I'm not slighting, but there might be certain situations which make it really difficult. So I guess what I'm saying is that to me, those are deterrents to having a truly more representative, group of jurors. I don't know how you change that, but.
So, I'm going to skip to you. Mr. Hutchison? Do you have any idea this trial was going to last 7 months when you began? Huh? How could you do that? How could the judge, how could you be punished so badly
You know what, why don't
by lawyers and
why don't we use this? Yeah, because this is a little bit.
So one of the things we are suggesting is, what we hear from all jurors, the trial lasted too long.
Yes,
It was too repetitive.
I would
We-
definitely say that.
We could, I mean, because it took you how many hours or days to deliberate?
To deliberate, it was like a half a day.
Half a day for 7
A
month
half a
trial.
day. So you're talking about 6 to 7 months of just, we're going over just, new information. I mean, they're constantly allowing new, things to be brought up in the case. Like each and every week, it was something new. Like it was just crazy.
So
And it's, yeah.
there's not, I don't know of any rule anywhere in the country that prevents judges from setting time limits on the amount of time in a trial. People are entitled to a day in court, not a week or a month in court. And judges around the country, we are trying to encourage them to set these time limits, divide the time evenly, and don't let something like that happen and tell you in advance, this trial's going to last so long. How did you,
Were you doing full days, for example, 8:30 or 9 in the morning till 5 each night, or was it broken up over a period of months?
there's another mic right there. Grab that other.
It was broken up as the trial went on, like further. But in the beginning, no, it was like 4 days, whatever. And if I can say the complaints was the compensation or whatever, that can definitely be better. Just the conditions as well. I think because the jurors were given like the worst rooms in the world, and it's like, oh well, that's the way we felt. So yeah.
So let me ask you this. One of the things that could be done that has not been done most places is create a fund that would compensate jurors. In other words, go to some, there's all kinds of charitable funds that could be created. You wouldn't ask the parties, but you would ask people like Jeff Bezos or rich people, to write a check for a jury welfare, jury fund or something that would supplement your salary if you were there. I think most people think that 5 days is okay, but beyond 5 days, maybe it's right to pay them a living wage. Ms. Smith, what would you say we need to do?
Does this one work? Can you hear me?
Yeah, we can hear you.
I think I'd never been on or gone to jury duty or anything, and I'm a preschool teacher, and it was hard to go get that one day off to go, and then I got a court. Oh. Sorry. And then I got a court order to give to my boss for 2 weeks, and I was like, oh, how am I? It was just scary to have to tell my boss that, hey, I'm not going to be back to teach for 2 weeks, and it ended up being a little bit longer than that. But it was a great experience. I loved it, and I thought it was really interesting, and that was just the only part I didn't like, was having to tell my boss, sorry. But they still paid me. They figured it out, and the money I got from jury duty just covered my Uber to and from the Daly Center.
Judge McWilliams, do you have to intervene for jurors with employer problems?
I have intervened with employer problems in the past. I've also intervened with educational issues like calling colleges or professors, that kind of thing, to put off exams. We'd like to let students go if we can, but really it's not for cause, in my opinion, because we would never have college students serving on juries, which I think is an important facet of the jury system. It did happen in a trial that I had last year, and I find that overall they're very accommodating when a judge calls, 95% of the time. And I know I'm not the only one.
Yeah,
Many
let me-
of my colleagues, I think, have
Yeah,
found that as well.
let me ask this question to you. We had one of these lunches on March 1st in Oakland, California. Now, one of the problems in Oakland, the federal court at least, draws from a huge geographical area. And traffic in San Francisco is tough to get around. People were driving 2.5 hours to get to the jury. Some courts, and all the courts in Oakland now, this was as true of all the courts, told me, they are now on a schedule where the trial begins at 8 in the morning and is over at 1:30 or 2 in the afternoon. There's no lunch break. You have a different kind of schedule, so you get there early, you break, and you have a half a day to go back to your job, have lunch. Apparently the jurors loved it there. Did any of you have some kind of modified schedule, or was just basically, Mr. Hutchison, you didn't?
I'm self-employed, so for me, it was able to, I was able to work around it. But for a lot of people, it was like a strain for them.
Mr. Kruger, what would you do to see if that mic works? The one that
I'm taking these away.
they aren't working?
I'm redoing all this.
That one's working.
It's working. Put that down.
Go ahead.
I don't know what your question was.
Oh, Ms. Demine, of course. Go ahead.
Oh, you want to talk about
Sure.
I skipped you.
the most unfortunate experience you got?
Honestly, yes, I would agree probably with the compensation, but outside of that, I mean, I'm fortunate that my company was very flexible. It was about a week-long trial. I had a very pleasant experience. Besides the compensation, I would say, I definitely would agree with that, but besides that.
Okay. Mr. Hutchison, your turn. Now, what would you like to see improved?
Okay. Again, improved. I would just definitely, besides compensation, just the conditions, that the jurors are in or whatever. I feel like, I'm not expecting, just the red carpet laid out. You definitely don't want that. You want to be fair. I definitely understand that. But just the conditions of the room and maybe, better food, of course. That'll make you think better sometimes, but, And just like you said, a time limit as far as evidence being, each week, it's something different or whatever. I just feel like the time limit needs to be constrained, especially for the time limit that I was there for. So, yeah.
Mr. Kruger.
Yeah, I mean, for me, I didn't really know what to expect, and had there maybe been a resource available online to maybe understand the process a little bit better. I'm kind of a technical person, so I sort of like to know what I'm going into prior to just showing up at a building and, here you go. So kind of felt like I was learning by the seat of my pants, if you will, and I'm sort of an individual that prefers to have a little bit of opportunity to be prepared, if you will. So,
Do you think, on that subject, a couple questions to you. Do you, in your case, did the judge I know the judge at the end of the case gives instructions, and I assume the judges did they give you each a copy of the instructions or only one copy? Do you remember? Did everyone in the jury room have a copy or just one?
one copy.
Okay, and one verdict form that had to be filled out. So would it have helped you to have, for example, each of you your own copy of those
Yeah,
instructions?
that would have been helpful.
Would it have helped you to get those instructions at the beginning of the, see, what we do in trials, I think, is in a way crazy. We make you sit there and listen to stuff for weeks and don't tell you what to look for or what the questions are going to be till you've heard it all. So would it have helped you to get some more instructions up front about?
Yeah, absolutely. Having, knowing more about the goal and the purpose initially up front will help us or would have helped me at least, formulate a little bit more clearly along the way, more pertinent information to pick out, so.
Suppose I could get IBM or Microsoft to someone, Apple, to provide jurors courtrooms in this city with iPads. So when you go in, you have an iPad that's wirelessly connected to the system. You have the instructions, you have the names of the witnesses, you have a abbreviated timeline, you have key documents that you're shown on the screen. Would that have been of interest to you?
Absolutely. I mean, the more information you empower us with and we're able to review, the better decision we'll be able to make. So I think that would have definitely have helped us along the way, or at least myself, and to be able to go back to things. A lot of times, for me, information later on in the process became relevant to something else that was previously discussed, and being able to reference that, with a tactile device in my hand would have been helpful.
If I could just ask all of you, show of hands, did all of you feel really confident about the facts and what your tasks were to be after opening statements were given? Sure. Were all of you feeling pretty confident about what you were asked to do and what you were tasked with as jurors after opening statements by the lawyers in the very beginning of the trial? All of you, raise your hand, yes? Okay. So for you? All right, thanks, Mr. Hutchinson. So, go ahead, Steve.
Ms. Thompson, what would you have improved?
I really enjoyed it. I've always been fascinated by the law and the process of trial. So it was nice to have an eye-opener to how it actually works, as opposed to what I've seen on Law and Order. I liked being inside it a lot. What I would like to see made better, I'm not sure how it could be made better, maybe this is the only process for it, was deliberation. It was about 7 hours long. We were basically just in a room, things got pretty heated, kind of yelling our points to each other. So I'm like, it has to be a more civil way to do this than, he who yells loudest, but that's kind of what it evened out to.
But it's kind of interesting. I mean, I tell people, the jury is the only institution left in this country that makes 12 people from all different backgrounds, all demography, all different, right, the left, all political spectrum, get in a room with the proposition that you can all come to an agreement on what the truth is. Mm-hmm. I mean, we live in and you have to talk to each other before you get out of the room. You have to listen to people. We live in such a divisive tribal society where, you just listen to people on TV going back and forth. The yelling and screaming that goes on, the divisiveness. The that jury service is the only time you're going to be forced in your life to sit in a room with strangers and agree on. We have trials because there's a presumption that there is a truth, and that 12 people can find out what it is. Look at the media. Look at the talk shows. It's quite different. Well, let me ask you this question: were you, in your trials, were you allowed to ask questions? And by that I mean right questions that were given to the judge, which either the judge or the lawyers then asked to the witness.
Can we have a show of hands with that with everyone?
I did. Yeah. And that was nice, too.
Who wasn't allowed to ask questions? Yeah, well, that's another thing. Some judges say, I allow questions, but they don't tell the jurors at the beginning. I'm going to allow, you all can ask a question. Here's how we're going to do it. They're instructions. They can give you a piece of paper, and everyone writes if they want to. That didn't happen. You were not encouraged or invited to ask questions. The ones who got to ask questions, Mr. Hutchinson, did you get to ask questions?
Yes.
Did it help?
It did actually help. And like the point that you was bringing up before a little bit earlier, the fact that is like maybe if there was an iPad explaining everything, it wouldn't be so much frustration in the jury room. I guess because at one time, like nobody really knows what they're doing when you're a first-time juror, when you're whatever. Like, let's just be honest. So, you're going in there and you're just like, okay, going on the fly, and they're telling you everything just like, at that moment's notice or whatever. So that's where a lot of the frustration comes in, is because a lot of the jurors, they don't want to say it, but they actually don't really know what they're doing. And they don't want to ask the questions because sometimes they're not allowed to ask certain questions. But if you have an iPad saying, okay, look, this is what you're doing, this is the plaintiff, this is the defendant, this is this or whatever, and break it down, sort of like a juror 101 class, then it'll be less frustration in the juror room. So,
Every
I
day
think-
we buy things off the internet, these machines and things that we have to assemble ourselves, like a bike rack on the car, which I had
That's
to do.
true.
Can you imagine sitting in a room with 12 people with only one set of instructions,
Yeah.
and everyone's supposed to be assembling this bike rack? How can you expect?
It's
people
sort of
to
like
come
a
up-
reality show. They should call it The Juror, because it's like everybody in one room, all these attitudes, and you can't go anywhere. So it's like, how are you gonna, this?
So we could help, for example, the judges could help by telling you how you should deliberate.
Yes.
For example, when you should take the first vote.
Mhm.
Maybe you should go around the room and have everyone talk before you have a show of hands. People say that gets views aired, because if you have a straw poll at the beginning and you find that the requisite number of jurors feels one way or almost one way, there's no need to talk. People get marginalized who are not in that majority, and it's better to go around. Some guidance on how to do it.
Yep. Guidance.
This goes to all of you, and whoever wants to comment, please let me know. I'll give you the microphone. How many of you really talked about the performances of the trial lawyers that were appearing in front of you, and if that had any effect on the facts and the deliberation of your case? You want to start here, Ms. Thompson?
I did. First off, it was the trial I was in. It was so many attorneys. It kind of was hard to know. Okay, what side is he on? They're coming from behind, and the next thing you know, they're talking, and I'm like, so maybe that's where the iPad would kind of keep us on track, where who is who, because it was just so many. But yeah, I think, and I noticed that the questions that we were kind of seeking the information on, they never asked, they never raised it. But when we did get a chance to write our questions down, they were then answered. So. Yeah.
Mr. Kruger?
Ms. Thompson, before we leave, let me ask you another question. Let's talk candidly about this. Diversity. Was there a diverse group of lawyers at the council table? You said there were a lot of lawyers. Were there women as well as men, people of color as well as white people? Tell us what impact that had, if any.
It was a nice group of men and women, but no, there was no diversity.
No diversity?
No. It would have been nice to see, but I don't know.
Do you think the judge and was it a woman or a male judge?
A male.
Did they treat, in your opinion, the women lawyers properly?
I think so. Yeah.
That's great. It's good to hear.
Seemed like an even playing field.
It's a big issue in the lawyers. We're looking for every kind of advantage we can get, okay, when we go to trial. So, thinking about who you put at counsel table and whether they're old or young, or
Yeah.
were the lawyers evenly matched, did you think?
They were, and the women were just as aggressive as the male lawyers, which I loved. So, yeah.
Who else? Who else thought the lawyers made it? Who thought the lawyers made a difference in the outcome? Huh? Better or worse? Yeah. Go ahead.
Yeah, it's the first time I've actually sat on a real jury, but the one lawyer that was for the plaintiff seeking damages was just like a bad TV version of a lawyer. And I got the impression that none of the people involved in the case really had any money. So this was just like a fishing expedition. I hate to sound so cynical, but it became pretty clear that even with the judgment, I was very much skeptical about any money was actually going to change hands, because it was two citizens. You know, somebody was injured by another. The one who was being sued didn't even go. He wasn't there. His lawyer was, but I guess he didn't have to be there.
Oh,
Mr. Kelly,
Doesn't send a great message, though, you know, like that he's not even there.
I think you're answering my question, but did you feel a little resentful of that? That certain people were not participating in the trial,
well-
however you were required to be there every day?
Like I said, my dad was a lawyer, so I kind of know courtrooms a little bit, but I guess resentful only in the standpoint that it kind of cheapened it. Like, it just gave me, kind of reinforced the idea that, like, is this outcome is there actually going to be anything that happens? Or, because the people that filed the suit, it seemed pretty desperate. And I think they probably got no offense, a hack lawyer because, I mean, because the chances of getting paid seemed very low. So, anyway, that kind of, I guess, that's my cynical perception, but that's kind of how I interpreted it.
how about, Mr. Kroger, how about technology in the courtroom? You said you are a kind of a technical guy. Mr. Kruger.
Yes, sir.
In your case, were things projected on a screen?
Yeah, they were.
PowerPoints and things?
Correct. And we had some, state regulations that we were reviewing, and the language is not particularly conducive to just normal people reading it. So, if we had copies of that and been able to look at it, because, we were continually referring to that throughout the case, and it would have been helpful to have a hard copy of that on hand and some of that material, as we're discussing it. So,
And even if it was not an iPad, a juror notebook, some judges are using just loose leaf notebooks where the key documents, the key laws are there, maybe, a timeline, a glossary of terms
Right.
to help people.
yep.
Was the technology effectively used in your case? I'll ask all of y'all that. Could you see what was being shown?
Yeah, I think it was sort of minimally okay. It was minimally effective. It was as effective as it needed to be. It could have obviously been enhanced had we had more of it, but it was, we saw what we needed to see. It just would have been helpful to have it more readily available along the process.
Were any of you forced to watch videotape depositions? You were, Mr. Was it horrible? What do you remember about it? Did you stay awake?
I didn't have any problem with the videotape versus in person.
Okay. Anyone else have video depositions? Yes, Ms. Doman.
Anything good or bad?
I thought it gave us a lot more, for the people that couldn't be there, because these were people that weren't physically there. It was nice to hear their side of it, especially as opposed to just, I thought we were going to have to read like the deposition, but we actually saw video of it, and that was nice.
If I could ask about expert witnesses, did all of you have expert witnesses in your case? All of you raise a hand so everyone can see? Okay, anyone have an experience, good or bad, or something that you talked about during jury deliberations that really weighed heavily regarding the expert witness's testimony? No? Was it treated as the same way as the lay witnesses, if you recall? No? Okay. Not a good question, because everyone's forget it.
Did they balance each other out, kind of, or was one much better than the other?
Well, I mean, I know personally, I did not the jury I did this time, but I did like a mock jury for a civil case going to trial, where we saw depositions on video. I mean, I think they're treated as equal, but the arguments here from both sides of the lawyers sometimes is that, that they're paid. So then there's a presumption that, maybe that they're doing this because they're getting paid. So that was introduced.
So I'm going to ask you a question I've been dying to ask someone. You are the first person I've had on a panel that has admitted to being both a mock juror and a real juror. Was anyone else ever a mock juror? You were a mock juror too. Okay, the questions to those who have been mock jurors. We have, as part of our project, as you heard, about 40 jury consultant advisors. They have created an industry around trials where they will go ask lawyers like me to hire them to do a mock trial. Because mock trials, I mean, they claim that you can get a reliable read of what the jury is likely to do from a mock trial. And my question to you is, did you take the mock trial as seriously you did as the real trial?
Steve, if you could repeat what she said? We can't hear
Yeah.
it. Or pass the mic.
Yeah, it recreated a trial situation in that it was a day long. I mean, I had to get there early in the morning. I had to hear the testimony and the witnesses and hear the arguments, and then we had lunch, and then we came back and heard the closing, and then went to deliberate. So it recreated certain parts of the experience as if it was a real jury, but of course, many things can't be 100%. There's no judge.
Ms.
And-
Kuhn, are you here? Would you stand up, please? Here is one of our jury consultant advisors in Chicago.
Yay.
What's the going rate for a mock juror? What do you pay a mock juror a day now?
Depends on how long the case is.
It's a day.
For a full day, about $300.
Would that be
That's what I was going to say.
that'd be what we kind of have to pay to make it. We let them do a play jury, and we pay them $250 or $300, but we don't pay. It's crazy, and
It's funny that you
we
said
have
that.
something has got wrong.
It's funny they say that because at the table I was sitting at, I said that exact same thing, that I'm help guiding a decision and getting $200 to $300. Plus, I know when it's ending. You know, like you said, it's for a day or two. And then the people that actually are making the decision are probably getting $20 a day. And yeah. So, I mean, I don't know if there's anything you can do about that, but that's just a fact.
Wow.
And obviously, it's worth it to them to pay people that money because
They think
they at
it's
least
reliable.
consider it. Yeah, exactly. I don't know how you measure that, but I assume you do think it's worthwhile.
All right.
As far as damages go, how many of you, with a show of hands, were asked to pay millions and millions of dollars? Okay, about half of you. Were any of you put off by that? Did you find that very daunting? And was that brought out initially in your trial?
I think it was brought up ahead of time, like, okay, if, this could be that much, you could be asked to pay this much money, or, to give out this much money. And it seemed like, okay, I could do it, but once you hear the actual amount, it does seem a little bit daunting. It was taken aback, but I just had to keep replaying in my head the judge's instructions saying, you have to decide on the facts of the case first, and then, you can decide the money part later. But
So now I'm going to ask the audience, because we have 8 minutes left, because I'm criticized when I conduct this and then don't give you all a chance to ask any questions you have. You have jurors here today, folks, so if you have any questions you want to ask of these people, please speak up. Well, if you can think of anything in the next 5 minutes, raise your hand or make yourself known, and you're free to ask them. Let me ask you this question. Go back to the beginning of the trial. We go through a process called voir dire in Texas, but it's a process where the lawyers ask you questions. What do you think about that process? Do you think the questions were designed? Well, you knew. Okay, let's put it this way. You know who the people were when you began deliberating, and you know what their views were, and you know what their backgrounds were, because you were then allowed to talk about that. Do you think the lawyers and the judge were successful in eliminating people who shouldn't have been on that jury because they were biased? Or some people, did you have some people on the jury that you wondered, how in the world did they get on this jury? Okay, now we're talking, okay? Now we're talking. Now, I don't want to know the particulars, but, well, I don't know how, you can tell me the particulars because it's a long time ago.
There was
So,
a girl in my jury group that just didn't care at all. Took no notes throughout the whole. I mean, I had a steno pad, and that's another thing. If we had more of the facts, like on an iPad or as a resource, we were literally going back in our steno pads, like, and another guy was like, "Yeah, I have that too," trying to convince the other people that. I mean, now it's like my word against what notes they took, and one girl took no notes, didn't care, and said, "I don't care. I will go whichever way you guys want." And I'm like, "Well, what is the point of you being here?" Just didn't care.
well, now, some lawyers, not me, are looking for furniture. That's what we call people. That's what we call people who, you get people to talk, tell them a little about themselves and here, and sometimes you can identify someone who's not going to be a leader, who basically will do no harm. Because what you're trying to get rid of people who are biased, unfair to your client. They're never going to be fair to your client. So you have a case where you had an indifferent juror, okay? So any other cases where you thought if the lawyer only asked the right questions, he or she would have found out about some person's biases or leanings or prejudice? Mr. Kelly.
This is both sad and funny, because the case involved two people being injured, and the judge said, the lawyer said, judge said, you got to act on the facts, not your emotions. And so we went in deliberation. The girl said, I think she should get this. And we said, well, why? She said, because she's just a little girl. We said, did you hear the part about, not your emotions? She said, I know, but she's just a little girl. And we literally were like, I don't know, how do you argue with somebody that doesn't even realize they're not following the instructions? So it's kind of sad and funny, but.
Mr. Hutchinson, I saw, in your jury, were there any people on your jury? Then the question should more properly.
No, I
Were there
understand
people
what you're
on
saying.
the jury who, if you were one of the parties, you would not, if you knew about them,
Yeah.
you would never have wanted that person on your jury?
No, definitely. It was definitely a guy that, I definitely kind of questioned his sanity or whatever, because he was just like, he would just belt out the most craziest things I've ever heard in my life or whatever. So I wouldn't say he was schizo or anything like that, schizophrenic, but it just didn't match, and I'm like, all of us are really trying to take it seriously or whatever. He's cracking jokes and stuff like that or whatever. And I'm like, okay, this is a malpractice case. Like, we need to take this serious, or whatever. So I would definitely say that was an experience of a lifetime for that.
Anyone else? Ms. Thompson?
I was just thinking, I have somebody that fell asleep. It was a week trial, 5 days, and I think he slept 3 of the 5 days. He was furniture.
But the interesting thing, what I'm hearing from all of you, which is very interesting, an interesting observation, is that there were bad jurors in the sense that they were indifferent or a little crazy or, falling sleepy or whatever. But you haven't identified a biased jury, really. I mean, what the judges in your cases allowed to happen was either they or the lawyers asked enough questions so that no one was back there in the jury room who, claimed to have been through something like this, exactly like this before. And was it? I mean, there were people who they were either had no mind or it was an open mind. Okay, let's put it that way.
I think they
Charitably.
weeded. It was a couple of people like that, but they weeded those people out. But even to the guy who fell asleep, I was like, this is a really interesting case. I was really intrigued by it. I don't know how he took a nap during it.
Case?
We have a question, Steve, if I can interject. Sorry.
Yes.
Hi. You've just been asked some questions about whether there were biased jurors on your panel. Did any of you serve on any panels in which you had a dominant personality or a dominant voice that led the jury or a number of jurors toward the resolution that he or she was looking for? Or was that counteracted by others on the panel?
Let's break that down. If we could, just for a show of hands, who had a very dominant person on their jury that really, like, was going to swing that vote one way or another? Okay, go ahead, Ms. Thompson, sorry.
Yeah, he didn't swing the vote, but he kind of led us during deliberation to, just examining certain facts, certain evidence, kind of, broke things up for us because it was all of us just kind of throwing our opinion into it, but somebody had to break it up into sections. How do we arrive at an answer? And he did that for us.
Was he the foreman?
Yes. He wasn't, but then we reappointed him. So he was by the end of the day.
Interesting. So studies have been done, empirical studies, where a lot of jurors have been studied. They say the conclusions are that the foreman of a civil jury that returns a verdict has a oversized effect on the result, that the foreman's very influential. In your cases, did you all choose your own foreman, or did the judge choose it for you? You chose it. Okay? And who else? Did anyone else have a dominant? Let me ask this question, going away question. After it was all over, were any of you curious enough about the parties, the lawyers, the judge, that you went to the internet, which you were totally free to do, and made some inquiries about things you were curious about? Huh? Yeah, afterwards. You did. Did you learn anything that would have had an impact on your decision?
Yes, actually. Like,
So,
after
okay.
doing that, I see why it's so important when you're sitting on a jury to not do that. Well, I don't know that it would have affected our outcome, but I could see how it potentially could have influenced a decision. So I understand why afterwards.
Mr. Kelly, anyone?
I think it's like catch-22 because, yeah, more information is generally good, but if it's presented in a certain way, it might kind of create a bias for you that would have otherwise not existed. I mean, this wasn't a case with me, but I could see that being a thing, you know.
Steve, could I sneak in one more question here?
Sure.
Here you go.
During your trials, and you're seeing the lawyers at the counsel table with their clients, either the party or representative of the party, two-part question. How closely were you watching the party or the representative of the party and what, their body language, and how much did any of that body language affect how you decided the facts?
Ms. Cunha. Tell
I
us.
do watch because it's very telling. At certain points in the let's say the proceedings, when there's some kind of thing that goes, the way there's verbal twist or the judge says something, there's some kind of reaction sometimes from the lawyer, the defendant's lawyer and the defendant that can be a bit telling, like a poker game, the tell.
Thank you.
Steve,
Listen,
can I just ask one more question
Yes.
from Judge Quinn here? Do you want to go ahead? No, you should. All right, yeah, because I haven't done here. So when the judges had a ruling one way or another, overruled or sustained, did that have any impact on what you were listening to or the outcome of the facts the way you saw them during the trials? Is there any moments that struck you? Was that your question pretty much?
Yeah, you know how we always, with jurors, we always say, listen, if I sustain the objection and someone says something, erase that answer from your memories and do not consider that. Well, do you guys consider that? Because I always wonder, like, well, maybe they kind of, Yeah, it's like, the elephant in the room is right. So I'm just curious, do you listen to the court when they tell you not to consider something like that?
I mean, myself, I listen, but like I think it's unrealistic to think that if you haven't heard something that it doesn't resonate on some level. And I honestly think some lawyers know that. They say it and they might know it's going to be sustained, but they want to plan it out there. I mean,
Okay, you only get $10 a day from now on.
anyway, just my
listen,
thought.
folks, this is the best panel out of 30 I've had, and you have fantastic jurors in Chicago. Thank you. Thank you very much for coming. What you told us will factor in the work we do going forward. We're using this, and thank you so much for coming and sharing this with us. Thank you. Thank you, folks.